Wonderful. Thank you all so much for being here. I'd like to open, John has offered to open us with a prayer. I'm kidding. No. I did not expect this many people, really, but it is an important seminar to have because we see mistakes being made with our giving. We want to give more and give Uncle Sam a little less, and there's just better ways of doing it. And some of these things might not apply to you, but if you get nosy with some of your friends or relatives, you can make sure that things are gifted at the right time and donated out of the right account or in the right way. And it just gets more money to the church in the long run. And that's so important. I'll tell a little story before I get going with the technical stuff. No, I'm not going to tell the story yet. First, I'm going to introduce myself. Michael Dayoub, CFP, Certified Financial Planner, here in Savannah, Georgia at Alpha Financial Planning. And I have also, in the second part of this seminar, Gennie Long with the law firm
Meyer and Sayers.
Meyer and Sayers. And Gennie is an estate attorney, and she'll be talking about planned giving in the second part of this. I'm going to be talking about tax smart giving in the first part. And just this whole giving thing, especially estate giving, is so important. I should probably save this story for when I introduce Gennie, but it's on my mind now. During the pandemic, I asked Billy about another church here in town. And I said, how is it they haven't had to lay anybody off? They're under no financial pressure at all. And the answer was just so obvious. They have built up so much from planned giving, legacy giving, that the church is never at risk. You know, they are solid through the ups and downs of the economy and world events, and it makes a huge difference. So it's important for us to make sure that we remember Asbury and Wesley Oak in our estates, and so that's an important part of this and a big reason for having this seminar. But we're going to pile it all into one seminar and first talk about tax smart giving. Now, I thought there would be maybe 2 or 3 attendees, so I did not print off enough. I promise you'll get an email, and if you need a copy of this, we'll put a link in the YouTube to where the PDF is for these slides, okay? But go ahead and pass these back and take one if you want one. If you can see just fine, then don't take one. If you can share, great. I only brought 10 copies, so I'm hopeful there will be a little sharing. All right, enough introduction. You kind of understand what we're going to do today. I think the whole thing will take about an hour. I don't expect to spend more than 20 minutes. I think Gennie will go a little bit longer. She's got a lot to cover. We also have with us today Kevin Pope, CPA. So if you have tax questions during all of this that you want to ask as part of the group, great. If you want to just pull him to the back and ask him a private little tax question, he was kind of a sweetener to just get people to show up. We said, hey, free tax, not necessarily advice, but tax questions answered. Which brings me to my next point. This is not legally advice. This is a general talk, and it does not apply. It may not apply to your situation. So these are not recommendations. These are just ways things get done and options for you. Is that enough of a legal disclaimer that this property taxes and your interest income, and you're so close to getting above that standard deduction, but you don't quite get there? Raise your hand if you've ever been in that situation. I know I have. I'm like, gosh, how come I can't beat the standard deduction? And it's not even worth it to keep track of all my receipts to beat that. But I'm so close. Why can't I beat that standard deduction? Do you know what we're talking about? Does anybody have a question about itemizing versus standard? So for single folks, you probably know this. I think this year it's $15,000 is your standard deduction. Standard deduction for single people. Yeah. And then for married, it's $30,000. Kevin just said it, but he forgot to turn his mic on. So that's a lot of deductions, but it turns out we're paying a lot in taxes and we're paying a lot in interest on our houses, and we're so close. But what happens is every year we fill it all out, our Schedule A or whatever that standard deduction schedule is, or itemized deduction schedule is, but we don't quite, this is the married illustration here, we don't quite get to beat the standard deduction. Well, how can you beat it? Well, if you give more one year to the church and less the next year, that's called bunching. And what it does is, if you bunch, it'll put you over the top. So on your big donation years, you can deduct, gosh, this person beat it by $6,000. They beat the standard deduction by $6,000. So they were able to itemize that year. And then the next year, no, they still got the standard deduction that year, even though they didn't donate anything to the church that year. So if you bunch your deductions, you're going to beat it. And when you don't beat it, you can still get the standard deduction. So you never lose. Yeah.
A question. To make sure that I'm understanding you, if my deductions are less than 30,000, which they would be, then I don't get to deduct?
Well, you still get the standard. Okay. Good question. So the question was, if your deductions, all your donations and your taxes, property taxes paid and interest paid, if they don't beat the standard deduction, do you still get to deduct those things? Well, you do, but it goes under the standard deduction. So this person, their donations and taxes paid and interest paid did not reach the standard deduction, so they still got to take the standard deduction on their taxes. For single they got to take $15,000 off of their income, and for married they got to take $30,000 off of their taxable income. Okay, sure. All right, so bunching works pretty well. You could do it if you can do it. Oh, this is a good one. Say you're a hotshot real estate broker or agent, and you finally sell that big house. You have that big year. You sold the mansion. You're never going to have another big year like this. So what you want to do is make your donation in that 1 year and stretch it out, and just make sure the church understands this counts for a lot of years, okay? And that way you've bunched it all. You want to bunch your donations for those big income years so that you're offsetting more income. All right, there's another way to get that done. I hope the next slide is donor advised funds, because that would be really cool if we could talk about. You guys got the basic concept of bunching here? All right, let's move to donor advised funds. All right, I had friends up in Atlanta, high-tech guys like myself. They had a big year. They cashed out. They were never going to have another year like that after they went public. And what some of us did was we set up something called a donor advised fund. And because we knew that we would never have another year that huge, and we wanted to get the maximum deduction for all our charitable donations for the rest of our working life in that 1 year. I mean, we're never going to have another event like this, right? So what we did was we donated it that year, that big year, into a donor advised fund. And then every year after that, we had a checkbook, and we could write out of that donor advised fund to whatever charity, as long as it's a qualified charity, as long as it's not, your nephew at college is not considered a charity. But other than that, if it's a qualified charity, you just write checks out of it So you have to call usually your broker and make sure that there's cash in there, because you're actually able to invest that donor advised fund in investments, and then make sure that cash coming out of it is available, and but you write checks to the charities that you want from that donor advised fund. And that was a way of bunching all the donations for the rest of your working life in a single year, but you can still pay to the church. And even if you change churches, you can pay to the next church if you're moving, or if you find new charities that you want to support or stop supporting, then you can choose as you go. So it's really a cool little checkbook, and Schwab does a great job of that, but a lot of the other brokerages do too. Now, what are some technical points about this? I think I covered it all. That's kind of what bunching, donor advised fund does. It gets you the bunching done in that one big year, because it's a huge tax benefit. Your tax rate that year, I mean, I've got the tax table further on, but when you have that really big year, you're paying almost 50% taxes when all is said and done. It's just ridiculous. So you want to deduct as much income as you can that year, and by donating to the donor advised fund, that gets you that big donation, or that big deduction, itemized deduction. Kevin, did I say all that right?
Yeah, that's right.
Okay. Yeah, a question here. Go ahead.
Yeah, so if you're giving, say, $25,000 to the donor advised fund, you take the deduction that 1 year.
Mm-hmm.
You said you're writing checks out of it.
Right.
So you don't get to So if you're giving something like $25,000 to the donor advised fund, you take that one-time deduction?
Yes.
But if you're writing checks to charities from that?
Yes.
Do you get to take that deduction?
No.
Yeah.
Here's
So how do you itemize that for the IRS?
Yeah, after it's, you just have to document that those checks went to legitimate charities, but officially, that's not even your money anymore. You're just writing checks out of it to the charity, but you got the deduction when the money went into that donor advised fund, when you got the most bang for the buck that 1 year. Does that make sense?
Yes.
Okay. Yeah, it's kind of funny, you know, it's not your money anymore once you put it in that donor advised fund.
No, that sounds great. Thank you.
Can you add to the fund after the initial contribution?
You certainly can, and hopefully you do it in a year where you get the tax, an itemized deduction. Yeah, try to bunch your donations on years that you want to put into that donor advised fund. So yeah, and some of my high-tech guys, they did have other big years after that, so it's possible, yeah. All right, enough on donor advised funds. Any other questions? All right, how are we on time? I feel like I'm going fast and rushing, but I'm probably not. I think we're right on schedule. All right, I've got just a couple more topics, and then we'll get to Gennie and planned giving. All right, you can't, now, Asbury is not in the used car business, but there are a lot of charities who will accept cars, and I think if that car was a certain value of a car, I think Asbury would be happy to accept it. In fact, but I would like, if it's a Corvette, I would like to drive it for a while and make sure that it's a legit, so that's a 65 Corvette there, I'm pretty sure. I don't know if I fit in it, but I'd like to find out. All right, so you can donate items to your church, and if it's an appraisable value, then, and the church is willing to accept it, then you can get the full value, am I saying that right? The full value of that donation. There are limitations it has in terms of how much you can donate or the value of an item. It needs to be, what, it can't be more than 50% of your income for the year, I think. Something like that.
Yeah, that sounds
Yeah, but yeah, if you've got an appraisable item of recognized value and you want to donate that to the church, Asbury will take it. We don't want your junkers. All right, what else do we have here? We've got cryptocurrencies. The laws are always changing on this. I'm not sure that people are getting the full value of their donations of cryptocurrencies right at this minute. I think that you almost have to cash it and then to get the full value, but there's dangers in that because anytime you recognize gains in those cryptocurrencies. Who here invests in cryptocurrencies? Does anybody? Me neither. I don't either. I barely understand them, so we'll just skip that. Okay. All right, so I think we're on about my last slide here. Oh, yeah, definitely. Stocks. All right, no, I've got 2 more slides, I know. A lot of us bought Home Depot a long time ago. Our parents bought it. It just crazy long time ago. And it has gone up so much in value that we can't sell it, because if we sell it, we're going to have this capital gains tax. It's just, so sometimes what we do is we just hold on to it and we hope that we can leave it in our will. Because when we leave it in our will, our heirs get the stock with a new value of the stock, and the current value. So they don't have to pay capital gains. So that's called a step up in basis, which is a really nice thing. But say that's all we have to give to the church. And we really want to make donations to the church. We can donate those shares as they are to the church and let the church sell them. And what that does is you get the full benefit of that donation. Whatever the value of those shares is, that's an itemized deduction for you. And the church sells it, and since they're a nonprofit, they don't pay any capital gains, and neither do you. So if you've got 2 stocks and you want to donate something to the church, always donate the one that has appreciated the most so that you avoid the capital gains tax. Do you guys know about that capital gains tax? I don't want to drag this out too much, but yeah, if you got a lot of gain in the stock and you sell it, you end up paying 15% or sometimes even 20% tax on that gain. All right, I'm going to let you, are you going to talk about houses and step up in value on houses?
I was going to talk about step up in cost basis generally, like you did.
Okay.
Not houses. You can go on and talk about houses.
Enough on, I'll let you talk about it from the estate purpose. But yeah, while you're still alive, donating highly appreciated shares is a cool thing to be able to do. You get the tax bang, the church doesn't have to pay any tax at all on the gains. All right, good? All right, one last thing. This applies to a ton of us. I'm getting there. We've been putting all this money into our IRAs every year, and it never got taxed as it went in to our 401k or our IRA, unless it was a Roth. We're not going to talk about Roths today. But as we're putting all this money in, our thought process was, well, I'll pay the tax later. When it comes out of the IRA, it gets taxed as regular income. You guys all understand that? Okay. Well, a lot of us, we get to age 73 and we don't really want to take it out of our IRA. We've got enough other investments, a pension, Social Security, income on the side, I don't know, but we don't necessarily want to take it out of the IRA. We don't need that money. And we hate to just take it out of the IRA because Uncle Sam requires us to take it out, but they do. They say, by 73, you have to start paying some tax on this. You can't just give it to your kids. You got to start paying some tax. You got to take it out of the IRA and pay tax at regular income rates, like a paycheck. Now, the idea there is, if we're not working, we have lower income. We were putting it into the IRA when we were at higher tax brackets. We're taking it out at lower tax brackets in retirement. But some of us still are paying too much tax as it's coming out of the IRA. A qualified distribution avoids having to pay tax on it. If you give a qualified distribution to your church straight from your IRA or your 401k, then it comes out without being taxed, as long as it's going to a qualified charity. And you satisfied what they call it the required minimum distribution, your RMD. So you satisfy your RMD, at least however much you donate to the church, you're satisfying that portion of your RMD. Now, sometimes your RMD is bigger than what you want to give to one charity or want to give to the church, or you need some of it to live on. So, but whatever you donate, you do a qualified distribution, and then whatever you don't want to donate, you just do a regular distribution to get it over to your other account and pay tax on it. Any questions about qualified distributions out of IRAs and
Do you get the full deduction, charitable deduction on the value of that distribution?
John, you mind using that so they'll get it on the...
Do you get the full value of the distribution as a deduction?
Well, no, because it was never income. So it avoids the income at all. But that's a lot smarter than paying it out of the IRA and paying taxes on it, pushing up your Social Security or your Medicare premiums. If you're taking too much income, recognized income, sometimes it'll push you up into other tax brackets for little things like Medicare. So taking it out of the IRA avoids pushing you up in a tax bracket. Even though if you took it out of the IRA, paid tax on it, and then donated it, it might work out the same in some situations, but sometimes it pushes up your tax bracket in other ways. So a lot of times it's just better to do a qualified distribution. All right, any other questions on that?
Your son said you need it.
Well, he doesn't always know. Is this new? Why have we not heard it
I don't
before?
know. I've been, Kevin, do you happen to know how long the qualified distributions have been around?
I don't know how long they've been around, but since I've been practicing.
Same
Which
here.
has been over 10 years. And I would emphasize them with, the standard deduction being so high. This is a good way to give to your church and get some benefit. And then you also can take the standard deduction. So it would just be excluded from taxable income.
Mm-hmm. Yeah.
Michael, what you're talking about right now, is that an institution to institution?
Let's see. What we do is we call Schwab and have them do a distribution from that IRA to the church. Yeah. Correct. Yeah, you don't want to recognize that as a distribution to you. And I don't think there's really a good way to do it without it being direct from the IRA straight to the charity. Yes?
You can write checks from your IRA to the charity.
That's true.
And you can do, I think it's $100,000 is the cap.
I forgot about that.
You can do up to $100,000.
Yeah. Yeah. Okay. I don't know if Barry got that on the
Can you just repeat what is said about that? Yeah, so $100,000 is the cap, that's correct. And then correct, emphasize, the trustee to trustee transfer. You can write checks out of your IRA, that's important to keep in mind. It just has to come straight from your IRA. You do not, take the money and then write the check. Those are the highlights.
Mm-hmm. You're right. I had forgotten though that Schwab does give our clients, if they want it, they'll give a checkbook and let the client write the check straight to the charity from that IRA. Yeah. All right. I think that concludes my portion of this little seminar. Here's tax brackets. I want to talk one more second about tax brackets because there's another trick to all this. If you retire at 65, and let's see if I can make this apply to charitable giving here. If you want to, you don't want to just wait till age 73 to start taking those required distributions. If you're able to get some distributions out of the IRA, before those required distributions, because you might be in a lower tax bracket until you get to age 73 when the required distributions kick in. So what we do for our clients is we try to estimate their taxes for the year and take enough out of the IRA to come up close to that tax bracket, or whichever big jump there is. There's a big jump here from 24 to 32% right now. So we call it filling the tax bracket. And that is a good time when you're age 70 and above to do qualified distributions out, even before the required distributions kick in. When you're living and with a low tax bracket, that's a good time to get money out of the IRA. And go ahead and give it to the church if you can. Yeah?
Do you have to do the qualified distribution before the end of the year, or do you get to do it within 65 days of the end of the year and throw it back into the previous year?
It's the end of the year, and we watch this so close. We want to try to get those checks to the church in the beginning of December, because we don't want a check sitting there getting accounted for the wrong year. There's actually a way to do it, but yeah, it's the end of the year. The IRS wants to see it done by the end of the year. There's a way to say, well, the check got written one year, but a lot of times the brokerage puts it on the wrong year. If it's just sitting in a desk at the church, you don't want that to happen. So get them done in early December. Just to make sure that everything's been correctly accounted in the right year. Did that answer your question? Yeah. Sorry for those of you online. The question was, is it calendar year, or do you get a little extra time like we do with some other things feeding into the next year to actually do that donation? But it's the end of the year, right, Kevin?
Yeah, that's correct. And just a couple other quirks with the qualified charitable distributions. When let's say, assume you have a $100,000 RMD and you give $10,000 to charity, your 1099-R is still going to show $100,000. It's up to you to report it on the tax return that you gave that $10,000 directly to charity. You'd indicate it by the code QCD on the face of the tax return. So just keep that in mind. I get that question all the time. So that's one of the things. And then also, typically your financial advisor will provide a list that confirms, but also it's up to you to keep up with records of how much you gave to the charities directly, and just provide that to your tax preparer.
Mm-hmm. Glad you're here. Thank you. All right, that concludes my portion of this. Now it's time for me to introduce Gennie Long, who has done work for a couple of clients of mine, and I'm thrilled to have you as part of this seminar. And as I said before, planned giving can put Asbury and Wesley Oak over the top and just keep all our ministries fully functioning no matter what the economy is doing. It makes a huge difference, and it's really not that hard to do, to add Asbury or any other charity as part of your will, and there's a bunch of different ways to do it. I'll let Gennie get into it.
Sounds good.
Okay.
Well, thank you. Thank you, Mike, for having me here today. And thank you to Kevin for jumping in with all the excellent tax answers. Yeah. I guess I'll go ahead and hand out. I also made 10 copies because he did not tell me there would be so many people, but I'm going to keep one so that I have one in my hand to go off of. So this is planned giving, and I'll go ahead and
do you want me to flip for you, or
sure. So my agenda is just an intro of myself, and then the topics that I was assigned, which are bequests, life insurance policies, retirement account beneficiaries, giving strategies to reduce your capital gains, which you kind of already talked about a little bit, and charitable trusts, and of course any questions. But feel free to raise your hand if you have any questions during my discussion. So,
Sherry, are we still good with the audio?
Yeah, I think so.
Can you? Yeah.
Barry, how are we doing?
All good?
No, they must be on the microphone to hear it.
They want what?
Is Gennie on?
It's green.
Okay.
I've never worn a microphone before, so if I
Okay. All right.
flip it off. Okay. So this is me. Again, my name is Gennie Long. I work at the firm Meyer & Sayers here in town. I do estate planning. which means that I help draft wills and trusts. I also help clients with probate administration. When their family member passes away, we advise them through the probate process or through the trust administration process.
I was going to have about 3 of these just to play a little joke on it.
Yes. As you can tell,
3 times.
that picture was maybe taken a few years back. That's all right. And so this is our firm. All the other male partners that I work with, we have a great firm. I really enjoy my office. But we are bringing on another female associate this summer. I cannot wait till she gets here.
That's awesome.
but
By the
it's-
way, we have a female advisor at my
Yes.
firm. Just thought I'd point that out. Yeah, a question.
Our office is located at 500 Stevenson Avenue. So we are what I would like to think of as smack dab in the middle of town. But we originally started on the landings in the village.
Can you speak up a little bit?
Okay, yeah, I'll talk a little louder. Should I move this thing closer?
I
don't
think
know.
they turned up your
Okay.
speaker.
Okay, well, yeah.
Okay.
Talking to my shirt. I'm just kidding.
All right, good.
So, okay.
Sorry.
So this is primarily what I do day to day. The topic is bequest, meaning that clients come in and they meet with me regarding what they would like to do with their estate. What may be a family issue that brought them there. It may just be regular estate planning in the course of things. And so primarily, most of our clients will get one set of documents that'll either include, more traditionally, I guess, would have been a will, power of attorney, advance directive for healthcare. So under your will, of course, you're going to leave your assets for a traditional family, to spouse and the children. But what I do see is that other clients do like to leave assets to different charities. It'll be maybe multiple charities. It might be charities with a theme. I have one client who's very big on animal protection, I guess I should say, or another client was very big on the environment. So it just may be their preferences, but I do see churches a lot. And even if there are children involved that are going to receive most of the inheritance, I do see a lot of them that will leave a specific bequest off the top of some set amount to the church upon their passing. And I think those are, churches rely on that, every charity relies on that, but churches are benefited from those bequests. The other type of documents that we're doing more often are a will, a revocable living trust, a power of attorney, and an advance directive for healthcare. The benefits of the revocable living trust would be a couple of things. One, privacy. So if you create a revocable living trust, that means that, again, you're saying the same thing that you would say under your will. I leave all of my assets to my surviving spouse, and then if my surviving spouse has predeceased me, they go to my children. Well, with the trust, all that language is kept private in a document at the attorney's office. So that'll be in our will vault. The will doesn't see it. Versus a will get filed, even if it's not probated, it will still be filed in public record at the probate court. So, for example, Elvis, I used to practice in Memphis, Tennessee, and Elvis, as you know, passed away in Memphis, and his will was widely available. So everyone, if whoever wanted to come to the probate court there, they could get a copy of his will, and they actually kept a stack of them and basically sold them. So anybody would come up there, they would grab one. And so his will says, who gets what and where and how. Well, the structure nowadays is that the will simply says it all is left to my trust. So for example, when Whitney Houston passed away, that's all anyone saw was, okay, Whitney Houston must have had a trust, it's at her attorney's office, and then it's no one else's business who got what from her estate. So that's the strategy we like to use, and then it also minimizes will contests. So it's very easy to contest a will here in Georgia, but to contest a trust, you've got to lawyer up and go to Superior Court, which means you actually have to have a valid claim or some sort of reasonable claim. So you can't just file a contest to slow things down or make somebody's life a little miserable. You actually have to have a reason to file that lawsuit. So we like revocable living trust for our clients. And then also, it does help avoid probate court. So if you are looking to transfer assets a little quicker, the probate court is very busy. They're well run. It's just, they've got a lot going on. So it does take a bit of a process to get appointed as somebody's executor. With the revocable living trust, your trustee is automatically already written in there. They can manage the assets literally the next day after someone passes away. Versus with a will and probate, we're looking at about 4 months right now before you finally get that letters testamentary that you can take to the bank. So I like the trust structure. Of course, there's other ways to avoid probate court by having your beneficiary designations up to date, joint accounts, things like that, of course Michael's very familiar with. But you know, it's not just the only way to avoid probate court through a trust, but it is a strategy that we really like to use for the reasons I mentioned: privacy, minimizing will contest, and then, of course, being able to manage the assets a lot quicker after somebody passes. And so the point of a revocable living trust, you can amend it, you can change it. So you basically, you know, you come in, you know, and 5 years later to say, okay, you know, I'd like to add these charities, or I'd like to add this person to my will or my trust. You can always come in and change it. There are irrevocable trusts, but that's a whole nother topic and another seminar. So, but anyway, but as far as the charitable distributions in your trust, much like your will, you would just say, I'd like to leave, you know, something off the top, maybe 10,000, 50,000, whatever it may be, or more, to the church, and then you might leave the rest to your family. Or if, you know, we have some, you know, clients who don't have, you know, family members, they may not have had children. They're the ones I see that are really very generous to charities. And so they would leave, you know, 50% of their estate to Asbury, and then, you know, 10% to this charity and that charity, and so on. So that's what I do all day long. So just sit there and write wills.
And it's just as easy to change the trust as it is to change the will.
Yes, just give us a call. We'll just change it and have you sign a new one. So, okay, so there are different types of bequest when you are making bequest to charities. Actually, since I have this lovely, wasn't expecting this. So because there are different ways you can leave assets to a charity under a trust or a will. It can be restricted or it can be unrestricted. And there are pros and cons to both, of course. And so the restricted is kind of like the name sounds, means that you place some sort of restriction on your gift. So it might be, I'd like to leave my funds to Asbury for youth missions trips, or, you know, the lunch on Sunday, whatever, just something specific, or the building fund, you know, or the organ, or, you know, I assume you have an organ. So, you know, something like that. Or you can just say it's unrestricted, which the church loves that, I will tell you. If it's unrestricted, that means they can use it for anything, which includes the day-to-day operations that every charity needs to fund, which is your, you know, utilities, salaries, I think I put a bunch of things on here, technology, rent, utilities, office supplies, training. So if it's unrestricted, they can spend it on anything that the board of directors or your vestry, I'm not sure what you have at the Methodist Church, but your finance committee determines. And so that's the difference between a restricted and unrestricted. So you could say, you know, just simply to the church, that would be an unrestricted donation, or you could say to the church, you know, again, for the purpose of, you know, youth missions or the, you know, organ replacement, whatever it may be. So, so that's where, but I will tell you, most charities like it unrestricted, in my experience.
Yeah,
so.
the churches, just speaking from the budget committee, it is a little bit to wrestle with what the actual wishes were and how we can actually satisfy those wishes after the need changes a little bit.
True,
So.
And that's part of the tough challenge of a restricted gift, is that, you know, if you're, you know, you no longer use an organ because we're using, you know, drums and guitars or something, you know, then your gift it's going to be sitting there and not be able to utilize how you wanted to. So the unrestricted gifts are certainly
Did I
a benefit.
too soon?
That's fine. Yes. No. So life insurance policies. So not only can you leave funds to your, you know, church through your will or your trust, but life insurance policies, similar to your retirement plans, can also be designated directly to the church or to your charity of choice. And there are several ways to do this. You can do this during your lifetime, but you can also do this upon your death. Most life insurance policies obviously pay off. So you've got the term policy where you purchase a policy for a low cost, and then it runs maybe a 20-year term. That you would list the beneficiary of the policy as a church, if that's some way that you would like to give. Of course, most of us tend to outlive the term of the policy, which is why the premiums are so low. So a better, if you're interested in life insurance giving, a better strategy would be if you had a permanent style of a life insurance policy, whole life, universal, that kind of thing. You can, again, name the church as a beneficiary, because they are still, as long as you keep paying the premiums, that is a permanent policy, you'll have it your whole life. And the church would receive the benefit of that death benefit, but you could also donate it to the church while you're alive and continue either paying the premiums on behalf of the church, or if you don't pay the premiums, the church would then cash it out right then with that cash surrender value. So those are some other ideas that, you know, some pros and cons would be that if you're, looking for, I can make these premiums and small payments, and then I can really leave the church a larger gift, like a $500,000 policy, and I pay the premium of $1,000 a year. That's a pretty big impact. So, it's something that it's a little creative, a little outside the box, but it is another option on the table.
Yeah,
So.
it'll work. The church can also choose to use some of the value, the cash value in the policy to pay premiums ongoing, so they don't have to cash the whole policy out.
I didn't want to spend too much time on that, but just
sorry.
let you know that that's out there. Certainly speak with the finance committee if that's something you're interested in. We can certainly go through that. I think I did mention that. The low cost, low impact, or large impact. And so another benefit of this is that you're already utilizing something you've already bought, so an asset that you're looking at, kind of like the IRA qualified distribution each year, that it's an asset you have, you're probably not doing much with it, think, why do I have this policy anymore? What else could I do with it? I don't need a whole life policy. I can give it to the church, they can cash it out, or use the cash value to pay the premiums until it pays out upon your death. And then you might be able to get an income tax deduction on that transfer of the policy to the church. So speak to your accountant about that. So, okay. And Michael did mention some retirement account beneficiaries. This is a very, very easy strategy to, if you've got a 401, well, not a 401k, sorry. If you've got a traditional IRA, it's very easy to write in the charity as your a full or partial beneficiary. So of course, again, you can say 100% to the church, or 25% to the church, 25% to Salvation Army, 25% to St. Jude's, whatever it may be. So that's a great strategy, very easy, that you can utilize these your own retirement accounts while you're alive. It's yours, it's for your benefit. And then upon your passing, if you want to leave 10% to the church and the rest to your family, that's also an option. Again, you would just specify the percentage to the charity, make sure you have the correct charity EIN number, that kind of information. Mm-hmm. And then 401k plans are a little trickier on this one. They are governed by ERISA, which means that if you want to leave your 401k to the church but you are married, your spouse has to consent by a notarized signature. The government makes sure that surviving spouses get 401ks and other ERISA plans. So if that's something you're looking into, certainly have a conversation with your spouse about that if you have a 401k plan. So traditional IRAs are probably your best way to give, but if everybody's on board, then certainly just sign the paperwork and complete it. But anyway, that's another strategy for leaving assets directly to the church without having probate involvement or, and again, the real benefit of the retirement account beneficiary is the tax savings. Your family members or just surviving individuals would love to have the life insurance. That's cash. You don't get taxed on that. It's just an asset. They're just going to get it 100% of what they're receiving. With the retirement account, the traditional IRA, for example, if my husband leaves me a traditional IRA, as I take those funds out, I've got to pay that income tax. So one of the very first places we're looking to give is retirement account assets, because income taxes have never been paid on it, and so now the church doesn't have to pay it, and so that's a wonderful thing for all parties involved. So,
good.
Yes, I want to talk about that. Let's see. To make sure I've got that. And you did cover the fact that they don't pay the income taxes, and then that's good. Okay, just want to make sure. I think my writing was a little small, so I'm trying to make sure I get all my details in there. So okay.
If you're doing a little checklist, a mental checklist on beneficiaries, I should add, your regular accounts can also be designated transfer on death, and that makes sure that your heir gets it right away. If it's just a regular investment account, it's just a nice thing to just avoid probate on those accounts. If it's called transfer on death, it's just.
Yes, I agree. And the same with bank accounts. This is something that I find that what will happen is, say they've gone to their financial advisor, like Michael, and they've got the big account, the IRA, they've all got these beneficiary designations. The house, we know where that's going because it's a joint survivor or joint tenants of survivorship. But then there's a bank account that's not much money, and that we end up having to go probate anyway over one bank account. But bank accounts you can also have, they can either be jointly titled, and if you don't have somebody to title your account with jointly, you can certainly name a beneficiary at the bank. It's just that the banks Michael's going to ask you that when you set up an IRA. Who do you want to, name as your beneficiary? But the bank doesn't necessarily think like that. They're just thinking, okay, who am I opening up the account in the name of? They're not necessarily worried about you passing away. And so we find that I've had to probate, $5,000 bank accounts, and it's just, feels silly because they've got to pay lawyer fees to do that and court fees. So just keep in mind the bank accounts. It's a little item, but it's things like that that can send you to probate anyway. So, and just so you know, I've asked some people in the know, but Georgia does not have a small estate affidavit process, and I wish we did. But so yes, to the extent you can, try to make sure that all of your accounts have either a beneficiary designated on them or a joint owner of some kind. So. And then capital gains, so this is kind of circling back to some things Michael talked about earlier. The cost basis of an asset, just to reiterate, he mentioned like Home Depot stock. So let's use that as a great example. So say you bought a Home Depot stock in 1990 for the cost of $50 a share, let's keep it simple. And now it's worth $400 a share. Well, that $350 difference is you will pay capital gains on if you sell it while you're alive. So I have clients, they'll ask me, this typically comes up with houses. I bought my child a house and I'd like to just go ahead and put it in that child's name because, they'll feel better about it. They'll feel like they have the asset in their own name and I don't need it, it's not mine, I don't live there. Let me just go ahead and give that to them now. And that's fine, except that my biggest problem with that is that if the client who's asking me that is maybe older, the step up in cost basis that your child would receive is far greater than the gift that you can give them right then. So the idea is I tell my clients to hang on to the house, keep it in your name until you pass away, and then leave it under your will to your child. And when your child inherits it and that they want to sell at that point, they don't pay any capital gains, or if they do, it's from the point of the value of date of death forward. So for example, like the Home Depot stock, say you bought your child a house, in Midtown for $150,000, and now it's worth $300,000, and you want to give it to them now. When you give it to them, they will take the same cost basis that you had, meaning that they will take it at $150,000 cost basis. And so they stay a little longer. They go to sell it for $400,000. They pay capital gains on the $150 to $400, or could potentially. There's other little factors at play here, but the idea being that if you had just simply died owning that asset, they would then get a new cost basis at $400,000. And so it's one of those things that capital gains, income tax, these are all considerations and ways that to keep in mind when you do make decisions like when to give a house to your child, when to give money to the church, or just these ideas. There are ways to maximize your giving and maximize your giving to your family and to your children. And so that's one of the ideas that with the capital gains, as Michael mentioned earlier, one of the greatest strategies you can have is that if you would like to give any shares, or say, okay, I want to give the church $5,000. Well, if you have $5,000 worth of Home Depot stock that you bought in 1990, that's a great way to give because you didn't pay capital gains on that versus you already paid income tax on the $5,000. So you're giving the same amount. The church is going to turn around and sell that $5,000 of Home Depot stock within the week that they get it, and they don't pay any capital gains on it. But then you got the benefit of giving $5,000, and they got the benefit of receiving $5,000 without having to pay taxes. So that's probably, I guess one of the biggest things you can do, I think, is the IRA qualified distributions and the giving highly appreciated stock. So.
Can I tell one story?
Please, yes.
So we have a client moving out of state, and we're currently begging him, please don't sell your house now, just rent it out, because, it's down there in the Victorian district. It's gorgeous. It's got $1 million in gains. If you rent it out for a few years, yeah, they'll tear it up. You'll have to pay some repairs, but it's just hundreds of thousands of dollars in capital gains we're talking about that he can avoid if he just puts it in his estate instead of selling the house right now. Yeah. Sometimes they don't want the hassle of renting out a house. Yeah. So we understand.
Okay, so charitable trust. This is one this is another strategy for giving, and this is not utilized as much. As I mentioned, the better strategy and more frequently used strategy would be giving your highly appreciated stock or your qualified plans of your retirement. But from time to time, we do have clients who would like to create a charitable trust. There are several different types of trusts, and you could fall asleep probably reading the different names, but there's a lot of acronyms. But the idea being that you create a trust similar to the donor advised fund. Actually, the donor advised fund would be a better strategy, it's, cheaper and easier. But if you would like to do a very significant amount of giving, you would put a large amount of money into a charitable trust. You can do one of two things. One, you can go ahead and have it pay while you're alive to certain you or your family members, and then upon your death, the charity gets the rest of it, the remainder. So that would be, and then the other one is the reverse of it. While you're alive, you put a bunch of money into the front load it, and it pays to the charity. So you would have, okay, I know the church is going to get, $5,000 a year off of this charity, off this trust, or $50,000 a year, or whatever, each year while I'm alive. Then the balance comes back to my family. So that's the charitable lead trust and the charitable remainder trust. So that it's going to flip of it. Who's going to benefit during your lifetime, and then upon your death, either you or your family, or your family or the charity will get it. So, and then so the charitable lead trust would be that the fixed annuity or the unit trust amount goes to the charity each year, and then the charitable remainder trust is where the remainder goes to the charity. So we have all these beautiful acronyms: charitable remainder annuity trust, charitable remainder unit trust, which is probably the most common one, a CRUT, and then there's a CRAT, and then there's a CLAT and a CLUT, and so it's just a little bit complicated. If this is anything that you're interested in, please schedule an appointment. And we'll go over it in more detail. But this is
the nice thing about this
beyond
trusts is they avoid taxes in a lot of cases for assets that are inside the trust as they appreciate and keep growing.
And I do find that the type of clients that are creating these, in the end, sometimes just keeping it around is almost more of a headache for the client itself. And so I've seen 2 of them in the last couple of years where they just said, we created this 15 years ago, we're kind of tired of messing with it, we just want to go ahead and just give it to the charity. So they'll get an income, a deduction for the amount that they would have taken themselves off of that income each year, plus the gift to the charity. So, they can be a little bit more headache than they're worth, but first, those that can benefit from it is also a nice estate planning tool that we have in our repertoire. So.
I'm trying.
Okay, and I think I know what the next one is. I think.
Keep going?
Sure. I mean, this just talks about how it actually works. So the idea is that it's irrevocable; it can't be changed. You establish a trust. You name who the charity is going to benefit from. You name who the income beneficiary is, either your family or the charity. And then the trust distributions are made regularly to either the donor or the charity, again, depending on charitable lead or charitable remainder. And then you get the income tax deduction when it's funded, based on, there's a calculation that's run. And then there are, again, capital gains taxes are avoided when you fund it with appreciated assets, like we've discussed many times today. And then they are sold tax-free inside the trust. They don't trigger any gains. So there are some different benefits of it. But again, and I guess the type of clients that are utilizing these things are trying to get money outside of their taxable estate. This is going to be, the estate tax exemption currently is $13.9 million per person, so roughly almost $28 million per couple, married couple. So we're talking about pretty high net worth individuals that are utilizing these as a tax structure.
I don't have that problem.
I don't have that problem, and unless I win the lottery, never will. So, but this is out there for some clients who need these or would like to utilize them. So the other charitable structures, Michael already talked about the donor advised fund, so I'm not going to go back into that. The private foundation, again, for the high net worth individual, that's another strategy for if you would like to have a family that would like to manage a private foundation for you. Usually need a board of directors. That's another asset, but again, that's for the high net worth individuals who would like to put the time and effort into something like that. A better strategy, and I think you're seeing this more, particularly in our community, is that with the private foundation, there are a lot of self-dealing rules and I guess places you could really trip up and be in trouble with the IRS. So donors are looking at the community foundation, and we have one here, the Savannah Community Foundation. I'll put a side plug. I am on the board of that, so if you have any questions, see me later. But it's a great way to leave assets kind of like in an endowment for charities. You could live, part of it could be for Asbury, and there's different reasons, different things you can do that. But with your estate, you can leave a certain portion to the Savannah Community Foundation. They will manage it and then make those distributions, if it's an endowment, really till, in perpetuity, for as long as there are funds there. And so I think that's a great strategy for clients who, well, I think it's a great strategy for a lot of clients, because setting up a private foundation is a lot of work and a lot of effort. And I will say, even somebody as wealthy as Greg Parker, he did put $20 million with the Savannah Community Foundation, and they are managing his foundation through the Community Foundation. So it's a way to sort of take the work and put it on somebody else. But you don't have to have that much. They have some as small as like $5,000. So it can be, they have a lot of funds of different sizes. So if that's something you're interested in, that's another way that you can have, you set up an endowment, and then Asbury would get, say for example, they would get the income off of about 5% a year in perpetuity. So if your estate had, even as like $100,000, if your estate was left to the Savannah Community Foundation, you could leave it to them and then have the Asbury Church, as the Methodist Church, as the income recipient, and 5% on $100,000 is $5,000 a year. And that's $5,000 that they don't have to ask for donations, they don't have to fundraise, it just comes to them regularly, and it will always be there because it's an endowment and the principal isn't utilized. So anyway, so that's another idea out there. And that's all of my part. I hope I check my time, but trying to keep here. Any questions? I see some hands. Okay.
Mark, here. Not have one, too.
Yes. I'm at an age where I don't know how long I'm going to live. None of us do. So it's hard to come up with a number, what you want to leave to whom. I have 16 grandchildren, and I'm 85 next week. So
happy birthday.
What I've done is I've done mine by percentage.
Yes.
So whatever my estate is when I die,
yes,
my grandchildren and my children, the whole thing, will get a percentage. So the end result doesn't matter in terms of the number.
True, and I agree. She's making the statement that her estate is done by percentages, and that's absolutely the best way to do it. There's no way to know what the dollar amount will be in your bank account upon your death, and so yes, we use percentages for nearly everything. The specific bequest might come off the top. If you are thinking in numbers, like I'd like to leave $25,000 to this, then that comes off the top first. And whatever's left, we still would use the percentages. So at the end of the day, there's a percentage somewhere.
A lot.
So anyway, but yes, that's a great comment for what to think about. Yes.
So if a trust does everything a will would do and you can not go to probate, why do a will? I mean, what's the advantage of a will then?
Sometimes, so some of our clients, I had one. I do simple wills for young families. They'll still have a trust for their children in it, but try really more the cost savings on the front end. It's just a little bit less work from the lawyer fees, so you can save some fees on the lawyer fees. I did have a client recently who came in, and they have accounts at probably 20 different banks, and you're just thinking, I can't get all of that to the trust, because to avoid the probate court, you've got to tie these assets to the trust. So for a house, I've got to deed it into the trust. For a CD, I've got to name the beneficiary as the trust. And for every bank account, I've got to list as my pay on death beneficiary the trust. And so that way it all comes into the trust, and then it's divided. For that client, I just thought there's no way. There will be one account or two that we don't get. We're still going to probate court. We still do all this work. And and it was going to take a lot of effort on the front end too. And I just thought, for that particular client, it wasn't really worth it. So it's more of a case-by-case basis. And some clients, like I recently have a new attorney client, and he says, I just don't like trusts. Okay, fine. You're not getting one then. So if you don't want one, I'm not going to give you one. But and so there's just different case-by-case scenarios. I would say 80% of our clients at least are doing the revocable living trust structure, but I'll still do what I call a simple will from time to time. So
it's moving in that direction?
Definitely,
okay.
Yes. And because I primarily am driving clients that direction just since my time here in Savannah. I moved here in 2012. When I moved here, the probate process for opening an estate was about 2 to 3 weeks. And now the court is just, perpetually understaffed, like every business is, and so, and they're doing the best they possibly can. They've really made a lot of wonderful changes down there, but I would say about 4 months. It's gone, and it just 3 to 4 months, and some of that's not in their control, and some of that's, some of that is in their control, and it just seems like the process doesn't go as quickly as it once did, and so for that reason, I look at it as almost trying to help them out and say, look, I'd rather not add to their burden unless we have to. There will always be plenty of things to probate, so I like to do the trust structure to, one, help my clients out, but then also think, at the same time, we're helping the court, the clients are saving money later, they don't have to call me back, we can just transfer these assets and they can move on. So yes, I'm trying to put most of my clients into a revocable living trust. So.
Yeah, the danger with a will, you want to keep the house running if you were to pass. You want to keep the family running. So there needs to be some money coming in, either from an insurance policy or in somebody else's account that'll keep things going. Because probate around here, they are just overworked and understaffed.
Yes, and so like, for example, I'll tell you what, in practicality, what that looks like is somebody is paying your mortgage for you, somebody's paying those utilities for you, and then you end up having to pay that person back. And so, that's one of the heirs, maybe the executor, they're coming out of their own pocket because they don't have access to your funds yet. And so the more you can do to sort of help that transition, the better. And certainly we do pay them back, they will get paid back, but for some people and some families, that's a lot to ask. So, actually, for a lot of families, like, why pay your own mortgage and someone else's? But knowing that you will get paid back, so it's kind of a tough thing. So.
All right. Any other questions?
Yes.
For the pay on death, could you do a joint account and then pay on death to?
So the question, and that would depend on the financial institution. The question was, could you do a joint account along with a pay on death beneficiary? And I am seeing that more and more banks are willing to do that. I think when I started my practice, probably 20 years ago, it would not have been the case, but I am seeing a lot more banks, Schwab, Fidelity, whatever it may be, you can have a joint account. So like, husband, wife would be on the account together, and then they would name a pay on death beneficiary, or even contingent after that. But it just depends on the financial institution. So you can always just ask the bank, hey, we have this joint account, would you allow us to put a death beneficiary? Because we're both not going to live forever. So I am seeing it more frequently, and have encouraged clients to even ask. But I never know for sure if the bank will allow that. So it hasn't always been the case. So that's a great question. Any others? Oh, yes.
I just have a comment. I'm a retired lawyer from California. And the importance of having a pour-over will with a trust is you can acquire property after the trust is created that isn't accounted for in the trust. And so then it can pour over.
So yes, so I think your statement was that we can create the trust, and with the assets you have at the time you created the trust, we move those into the trust. And then, yes, that is always a concern that perhaps, and this did happen to me, and it will happen to me again, but after, so say you've seen your attorney, we've gone through this whole process, we've put assets in, and then you go shopping, you go buy another house, or you go open up another bank account, or open up another retirement account, and you forget to name the trust as the beneficiary, or retitle that next property into your trust. I have a client who, I am not kidding you, they signed their wills and trusts in August, and then September he went and bought a boat slip. I didn't know you could buy these things, but you can buy a boat slip in Hilton Head. And so they have, and it's like a real estate asset basically in South Carolina. So a boat slip has a deed just like a house, and so that became, probate property. So not only, and then because it was in South Carolina, we had to open probate here in Georgia that's where he died. He was domiciled here, so you open it here, and then we not only go to Hilton Head to probate it in Beaufort County probate court with an ancillary probate, all for a $50,000 boat slip. So it was worth something, but everything else was tied, I had gotten it all organized, and then, I don't know, but a month later, I was shocked when I saw it. It was like a month later after, we got it all organized, we went and bought this boat slip, and then, several years later he passed away, but, we discovered, so yes, you can always fixed it. The only thing, of course, we had to probate was the boat slip. But again, it was because, you know, I just didn't even think, oh, I went, you know, went and bought something else. And so yes, the key is to try to keep those assets titled in the trust, or at least a death beneficiary, the designation going into the trust, so it connects at some point. We'll get it there anyway through the pro order of a will, as you mentioned. So we did probate. Of course, with the probate, the will said it all goes into my trust. It still went to his wife, but there were about 5 more steps in there that didn't have to be there. So anyway, that's a great statement because it reminds you of the things you would wish you could have done differently. I know we've kept you guys here a long time. I don't know if there's any other final questions or thoughts.
I had a couple more random, here's Gennie's contact. A couple more random thoughts. Just, I think, thank you for coming, number one, and just estate giving is just a way of leaving a legacy for the church. I look at stewardship, that word is about a responsibility, and it's more than just a responsibility. It's your affection for our church and our community and what we stand for. And legacy giving is a great way to make that statement. And I wanted to say one more thing about that. We have something here called the Tree of Life plaque with names on it for significant givers during life and in death. And names go on that plaque. It's a meaningful thing for someone to get their name on that plaque, and the church honors those givers. Anything else I should say about that, Billy?
No, you did it.
Okay.
Thank you.
All right, but thank you. I think that for me, and I'll just close on stewardship with this, it's more than just a responsibility. It's your chance to show your love, for whether it's stewardship of the environment and your love for this world, or stewardship of this church and your love for the what we do here. Yeah. You are allowed to ask Kevin whatever that was a sweetener. Whatever tax questions you have. Kevin, do you have any general comments on taxes, good or bad?
I think we covered it all, but yeah, if you want to, contact me after this, or, we can share my email afterwards, and you can also email me directly for questions. So I'm happy to take some.
Thank you for coming, Kevin. I couldn't have done it without you. Serious. I'm just not that accurate.
And Kevin is at Tucker and Company, and Jeff, of course, is a member here, has been our finance chair a couple of times. Thank you, Kevin. Oh my gosh. Gennie
Yes.
with a G. Yes. Gennie with a G. And Michael, thank you so much for this. You get a free Wednesday night supper for doing this. But thank you. It's funny, too. Tom Bordeaux is one of my oldest friends. He and I grew up together on 65th Street. He's the probate judge, but we never talk shop when we're together. And but his wife Nell is a minister, and she's actually going to be here Wednesday to help lead our noon Ash Wednesday service. But I know he'll appreciate you taking some work off of him in the probate court. Thank y'all so much. This helps. Especially me. I'm not good at this stuff, so this really helps. Thank you so much. Thank y'all, too, for your love, care, and concern and interest. Blessings. Have a good Sunday.
Thank you.
Thank you.
All right,
Michael.
good job.